Well, good morning, everyone. Thank you for being here so early it depends on which time zone I'm assuming that you're in, but early for some of us. We have a wonderful session set up today, but I wanted to start by actually announcing a few things before I announce who it is we are actually going to be talking with in just a few moments. Our session today is called Disabilities and the Courts. It's part of the Stop the Stigma conference. It's hosted by both the community and Moxie Educational Services. As part of Stop the Stigma, we acknowledge the importance of person first language because language shapes how we understand one another. First person language centers humanity over diagnosis or system involvement and reflects our shared commitment to dignity, respect, and equity. We also recognize that individuals may prefer identity first language, and we encourage speakers and participants to honor personal preference whenever possible. We would also like to begin with a land acknowledgement. Although this conference is held virtually, we acknowledge the Indigenous peoples whose lands we occupy as we gather, learn, and collaborate. The community is headquartered in Milwaukee, Wisconsin, on the traditional homelands of the Ho-Chunk and Menominee nations, the Potawatomi Nation, with enduring ties to the Ojibwe and Odawa peoples of the Council of the Three Fires. Moxie Educational Services is based in New Hampshire on the ancestral lands of the Abenaki and Pennacook peoples, whose histories and cultures and sovereignty continue today. We honor the resilience, ongoing contributions, and enduring relationship to the land. This acknowledgement is only a beginning, and we encourage all attendees to learn about the Indigenous nations whose lands they reside on and to support ongoing efforts toward Indigenous justice and sovereignty. I'd also like to talk a little bit about accessibility in terms of how we view accessibility, and that is a shared responsibility. And I thank you for helping create a conference culture that's rooted in respect, care, and openness. ASL interpreters are provided for each session, and CART captions are activated. To support blind and deafblind attendees, we'll begin with brief visual descriptions, and I'll go first, and then invite each of my colleagues to do the same. So my name is Beth Koenig. I'm a white complexion female with very rosy cheeks and medium length hair that's pulled back in a bun. It's medium gray with some silver streaks by both temples. I have blue eyes and I'm wearing a kind of funky, slightly cat-eyed glasses with a matte gold panel at the top outlined with a thin black line. I'm wearing a hot pink sweater with gold buttons and gold hoop earrings with a blurred background of a lamp and bookshelves in my home. Margot, would you like to go next?
Sure. I'm Margot Schlanger. I'm also white and have a brownish hair. I like to think of it as brown. It's probably really gray. And I wear glasses. I'm in my office, which is blurry in the background, but has a lot of books.
Thank you, Leanne.
Hi, everyone. I'm Lee Ann McKingsley. I'm a white female with medium length hair that is blondish white. I have blue-green eyes and I'm wearing a cream-colored V-neck top. I'm using a background screen that resembles an office space with an orange, mostly orange background with the ARCS logo.
Lovely. Thank you both. As a reminder, Margot, Leanne, and I will do our best not to use acronyms. There may be one that slips here or there. If it is not something that you recognize, please do ask about it in the chat and we will try to address it. The chat is open and we encourage you to engage with people. Please be respectful and inclusive. The Zoom microphones and cameras are set to off for all attendees by default. And if access needs arise during the session, please try to indicate that and we will pause and flag them. So in the interest of time, and because this information exists in the conference program, I will briefly introduce my two guests. Leanne McKinsley has a background in social work and public administration and is the Senior Director of Disability and Justice Initiatives for the ARC of the United States, where she founded and directs the ARC's National Center on Criminal Justice and Disability. which is a clearinghouse for research, information, evaluation, training, and technical assistance for criminal justice and disability professionals focused on people with intellectual and developmental disabilities. Margot Schlanger is the Wade H. and Doris M. McCree Collegiate Professor of Law at the University of Michigan and the founder and director of the Civil Rights Litigation Clearinghouse. She served as the reporter for the American Bar Association's revision of its standards on treatment of prisoners, and is the lead author of a new casebook, Incarceration in the Law. Professor Schlanger was the court-appointed monitor for a statewide settlement dealing with death prisoners in Kentucky, which we'll talk a little bit more about today. I'm thrilled to have these exemplary women join us here today, and so let's jump into a conversation. Although our session is entitled Disabilities in the Courts, we thought it would be wise to do a little level setting. So when talking about disabilities, we're trying to take into account the wide array of disabilities that are both seen and unseen. And we recognize our time constraints today. So we're going to try to keep in mind physical, cognitive, communication disabilities, as well as individual considerations and systemic challenges. So with such a large and diverse audience, which we're thrilled to have, I'm going to ask Margot a few questions first. And the first is basically to just kind of set the stage for us and talk a bit about how the many touch points that exist in the criminal legal process, from one's first interaction with law enforcement onward, affect an individual. So it's kind of like the individual's journey. And then what does equality look like from a one-on-one individual perspective, including whether there are any limits? Margot?
Great. Thanks so much for having me. It's really great to be here. So if we think about the path through encounters with the criminal legal system, we could start with a law enforcement encounter that may or may not lead to booking, to court, to attorney meetings, perhaps to jail, perhaps to prison, then maybe a parole hearing, and then parole itself. So that entire range of encounters with the government are important for us to consider when we're thinking about disability justice and disability equality. And all of those are covered by the American statutes that relate to disability. So there are two of those statutes that I want to talk about today. There's the Americans with Disabilities Act, which I'm, notwithstanding our desire to avoid acronyms, I'm going to call the ADA because everybody does. And then there's also Section 504 of the 1973 Rehabilitation Act, which I might mess up and sometimes call either Section 504 or the Rehab Act. These basically do the same thing. They have kind of different scopes in ways that I don't think really matter for us today, but they both apply to governmental encounters with the public. The Rehab Act, the Rehabilitation Act, applies to government entities that accept federal support. And so since that's pretty much all governmental entities, that means it applies to everything we care about today. So together, these statutes prohibit discrimination on the basis of disability in federally conducted, federally supported activities and in state and local government services more generally. There was for a while an effort to exclude, an interpretive effort to exclude jails and prisons in particular, and we are actually seeing some remnants of that in policing encounters. And thus far, the courts have said, no, those are not excluded. Those are covered. The Supreme Court said so in a case called Yeski in 1998 about jails and prisons. The issue is still being somewhat fought over about policing, but thus far it seems that the courts are holding the line, as I think the statutory language requires, and saying, yeah, everything, all of it, government services, programs, activities, all of it. So what do all of those encounters need to do? Well, they need to provide the phrase that gets used often is meaningful access to qualified individuals with a disability. And so, meaningful access basically means equal access. So, for example, um, if a person who doesn't have a communications disability can have a conversation with a police officer, then that conversation is a government activity. And so that government activity of communication with members of the public has to be offered meaningfully to people with disabilities, including communications disabilities. So that's the basic idea. So there's a whole bunch of theories of liability, theories of responsibility. There's a requirement of physical access um, in the ADA, which required that new construction, remember the ADA has been around for a pretty long time, so new construction is older than my students. It's a construction that is after January 1992. New construction has to be readily accessible and usable by people with disabilities. And even older construction comes into the new construction category if it's had certain really significant remodels. And even if it hasn't, it has to provide program accessibility. So, what that means is that if you're a government and you haven't done any construction since, the early 90s, you're still covered as far as physical accessibility um, uh, by the ADA. Not every single room has to be accessible, but you have to provide enough physical accessibility that people have access to your programs. So that would mean, for example, in a prison, that if classes are offered in a very old facility, and we all know that lots of prisons are very old, if classes are offered in a very old facility and they're up a steep flight of steps, you can't just say if you're the prison, hey, but it's really old. We're not covered by physical accessibility requirements. The answer is no, there's program accessibility. You got to offer classes in a place where a person with a mobility impairment can get to them. Okay, so that's physical accessibility. There's also a requirement to avoid disparate treatment. And what I mean by disparate treatment is a treatment that is explicitly because of a disability that treats folks disfavorably. So, for example, maybe in a particular jail, all the people who use wheelchairs, or maybe all the people who are blind, are um, sent rather than to regular housing facilities, they're put in solitary confinement cells and not allowed out. And maybe that's even on a theory that it's better for them because they're vulnerable if they're allowed out. Well, that's disparate treatment. That's discrimination. And the law says, no, you can't do that unless there's an individualized assessment that it really is necessary, that there's safety risks that can't be mitigated in different ways than that kind of discrimination. So in all of the systems that we're talking about, that kind of individualization does not come easy. And so we often see very, very major obstacles to full participation and equal treatment that are explicitly discriminatory, and that somebody says, well, yeah, but it's about safety, but they haven't done the kind of individualized assessment of safety needs, of the possibility of modifications that can address them. Okay, so that's the second one. I'm trying to go fast, but I've been asked to do this. So the third requirement of the law is a requirement of what's called reasonable modification. And generally speaking, in this world, people don't use that phrase. That's the statutory phrase. But instead, they use the phrase reasonable accommodation. It doesn't much matter. Either one is fine. But what that means is that when something that's not on its surface, on its face, it doesn't look discriminatory, but it operates in a discriminatory way, then there have to be modifications or accommodations that allow people with disabilities, again, equal access to that program, service, or activity. So, for example, if you have a court that does not um, that when you have somebody who has a hearing impairment, maybe they're deaf and use sign language, maybe they're not deaf, but they just don't hear very well. And if you have a court that is dealing with that person and they don't offer various kinds of accommodations that allow that person to understand what's going in court, well, then that court has violated the reasonable modification provisions of the ADA and the Rehabilitation Act. Um, and there's a lot of things that reasonable modification reaches that have to do with making sure that people with disabilities actually get equal access to program services and activities. If you've got a person who can't read because of a disability, you can't just hand them a written document and think that they've understood it, right? So figuring out a way to communicate more effectively with somebody with who can't read, perhaps they're blind, and perhaps they have an intellectual disability. Either way, you've got to figure out a way to communicate with them. That's the reasonable modification requirement. There's also a requirement of effective communication. This is for communication that's from the state to the individual, um, and that is even more muscular than the requirement of reasonable modification, and covers people who have communications disabilities. They're deaf, they're blind, they have low vision, they're hard of hearing, they have speech impediment. So you name it. Effective communication says the government has an obligation to communicate effectively with such people and to offer them auxiliary aids, which could be the kind of interpretation we're having in this call. It could be something quite different than that. There's all kinds of possibilities. So that's effective communication. And finally, an integration mandate that the requirement of non-discrimination means that the government has to provide services for people with disabilities. um, it can't condition those services on those individuals taking themselves out of the community and being segregated in some way. It has to offer those services in the community if it offers them, if it's going to offer them, and avoid encouraging or even insisting on segregation of people with disabilities. So I've spoken for a little longer than we talked about me talking for, so I'm going to stop. All of this applies both to courts and to the other people, the other pieces of this process. And as we get into it, we'll talk about that in a little bit more detail.
Thank you, Margot. And actually, we're this is a free-flowing conversation, so we can adjust for time always. I'm going to give Leanne a couple of questions while I pull up this particular lovely document that she shared. ARC, where Leanne is at, has a wonderful program called Pathways of Justice, and Leanne has worked for over 30 years in the intellectual and developmental disabilities arena. So as I pull this up, this particular visual will map out kind of an individual's process in terms of what the legal process looks like. So I will ask Leanne to start talking about some examples of positive steps that are taking place for individuals with disabilities as they journey through this legal continuum, and then what kind of accommodations have been helpful for someone going through the legal process. And then, of course, it wouldn't be real life if I also didn't ask her to highlight some of the challenges or areas that maybe have seen the least amount of movement or progress. So,
Right.
Leanne, go ahead
While you pull that up, sure, I'll
I'll
get
pull this up.
started. And thank you so much, Beth, for working with us as we prepared for today, and to Ben and the organizations that made this day possible. It's so important to have this education, and I'm very happy to be part of it. So thank you. Um, so I've had the unique kind of opportunity to see this issue. As Beth mentioned, I've been in the field for 30 years at the ARC of the United States, and then we got the opportunity to create the National Center on Criminal Justice and Disability 11 years ago. And so it's given me the opportunity to kind of see the good, the bad, and the ugly of all of these issues. And I think in terms of positive steps, we have seen that there's more awareness in general around disability issues within the criminal legal system throughout, from first responders throughout the court system. There has been more awareness, I think, because maybe of certain types of disabilities, such as autism, people knowing more about disability in general. And I think that that has helped create this awareness. However, on the other side of that, that doesn't always translate into accommodations or accountability around accommodations and ensuring that those are provided. And that is why we need the law, the Americans with Disabilities Act, to ensure that there are tools and ways to not only educate about this issue, but to hold entities accountable around accommodation and access. So, I wanted to share with you this Pathways to Justice model as a visual for understanding the different steps that someone might go through as they enter the criminal justice system. And just a brief description, basically, it's a kind of a chart showing from community to first contact to investigation, onto jail, then to trial plea agreement, transitioning back into the community. And each section or each stage has a different color associated with that to really help each stage stand out. And in the upper and lower corners, it talks about the different steps that someone might go through as they're going throughout this system. The first one is identification. So we want to ask, how is disability being identified? There may be a physical disability, but there may also be disabilities that are not visible. And that is often the individuals we are very concerned about who come into the system because it can be very hard to identify disability at times. So, identification is the first step. Secondly, accommodation. So, what types of accommodations are being provided or not being provided at each stage? And then lastly, support. What other kinds of support does that person need, whether they are headed into the criminal justice system and we're trying to prevent that, or they're already in the system and needing to access services. So, just for some examples, if we look at first contact, some data actually shows that the public safety and legal systems personnel have limited experience with and knowledge of people with disabilities. One study found that police accurately identified individuals with developmental disabilities, for example, only 30% of the time. Although many of them were confident that they could identify disability. So, one accommodation might be when an officer may think that a disability might be present. And this, again, this is first contact. But if you think through the entire system, this could apply to an officer, an attorney, someone working within prisons and jails, probation. It could apply to everyone. If someone thinks there may be a disability present, then you can ask things like, do you have an ID, or where do you live? Where do you work? To try to get some more deeper information. Some individuals have you attended special education classes, for example? So again, when looking at disability that's hard to identify, it's important to dig deeper and not just assume anything until you know more about the individual. This, of course, continues into investigation, where there has been information showing just how often people with disabilities and IDD specifically can give false confessions. Many people don't understand the Miranda. And so an accommodation could be to provide a Miranda that is in plain language and where you ask after each piece of the Miranda, can you explain to me what I said using your own words? And of course, even then, we can't always know for sure, but it's important to step back and make sure that that person's rights are protected. We're actually working on a project right now with the International Association of Chiefs of Police on a project that is looking at developing guidelines and protocols around how we can interview or within interrogations someone with disabilities in a more effective and fair way. And then moving on to jail, of course, we know that people with disabilities can be extremely susceptible to victimization in jails and prisons. They can be punished for rule infractions they may not even fully understand, and removed from the general population and even placed in solitary confinement for extended periods of time. So when we think about access, and sometimes even when we try to do, quote, the right thing, we may actually harm that person even more. So again, it's focusing on equity within jails and prisons and making sure that if there is any question around what should be provided, to work with the disability community to better understand that. So there are more to that I could talk about going on, but I want to make sure I stay in our time frame. So I wanted to mention one other thing around research, because I think that's another area where we need quite a bit more work. And in November of 2025, last year, I spoke on a panel by Pew and the RAND Corporation, where they held a meeting to address research gaps. And they created a report titled Disability and the Legal System, a proposed agenda for future research. And they start off that report saying that more than a quarter of U.S. adults live with a disability, but little is known about their experiences in the legal system. I think that's a page turner right there. When we actually understand how many people with disabilities are involved in this, this huge system, this complex system, and how little that we know about it and how little we've actually researched it. It really opens up an understanding of why sometimes in this field we just feel like we go in circles with information because we're not getting the data that we need. So I highly recommend that as a resource to look at thinking ahead and how do we keep people with disabilities who should not be there out of the system to begin with, but then how do we provide accommodations that are evidence-based, that we know can work, and that we can build on that research in the future. So that's some of the good, the bad, and the ugly, and I hope that kind of lays some of the groundwork for what we'll be discussing next.
Thank you, Leanne. I appreciate that. There is one, while I stop sharing and move from one place to another here, there is one question that came in that I thought I would just throw out to both of you quickly while we transition into the next set of questions. And that is there any recourse for individuals who are not accurately diagnosed before they are sentenced? I don't know if, Margot, you want to weigh in on that?
I think that if if somebody if somebody has a diagnosis that's relevant to their sentence, then they need to pursue it through appellate procedure or habeas. I mean, there's not a different way to do it than that. So it's kind of the ordinary structures, which are not great structures, let me just be clear, but the ordinary structures for seeking review of a criminal proceeding are the same structures that apply if the reason for the problem is a disability problem.
Great. All right, so we're going to move on into our next section here. I'm just pulling it up for one moment, if you'll bear with me. Let's see here. Okie dokie. So our next set of questions really are kind of around some things that have been going on, and some of these go back about 10 years or so, but I'm going to ask both Margot and Leanne to take maybe about 5 or 6 minutes. Margot, I'd love for you to be able to talk about the Knights or Adams and Knights v. Kentucky case, what it was that you did, your role as monitor, and what, if anything, you feel changed or kind of has come about due to that particular case?
Sure. So this was a case that was started by a couple of folks in the behind bars in Kentucky who were capital D deaf. They both used sign language to communicate, and they were excluded from programs, services, and activities in the Kentucky system in a variety of ways. So, when people tried to communicate with them, they tended to pass notes as opposed to having an interpreter. When they wanted to talk to their family, they were told to use either to that they couldn't, or to use a TTY, which is a really outdated and bad and not effective technology for people who sign to communicate. So they brought a lawsuit, and it was they were represented by some public interest lawyers, and it was eventually settled with a kind of class-wide settlement, which said that both for deaf and hard of hearing people in that system, there needed to be a lot of change. There needed to be, along the lines that Leanne was just talking about, there needed to be a system that detected who had the set of needs that were related to hearing. So that was less necessary for people who are deaf and use sign language, and more necessary for people who are hard of hearing. But there needed to be a system of detection, of planning, because accommodation doesn't work without planning. I'll talk about that in a second, of accommodation and then a feedback loop to figure out if things were working. And so, as part of that, the settlement said that there would be a monitor, and I was appointed to be that monitor. And I then wrote reports. I went to every prison in Kentucky, and I figured out as best as I could what was going on related just to this one set of issues, right? Deaf and hard of hearing prisoners. Um, and wrote reports. I helped develop training for the corrections staff. I did a lot of review of medical records, talked with people about what kinds of technologies they might be able to use, and I wrote reports both for every visit I did, and then for the entire system every 6 months. That settlement lasted for over 5 years, but eventually it stopped. It went away. The system made pretty significant strides. I wouldn't say they got to, perfect by any means, but they made some pretty significant strides. They started doing hearing tests of people routinely as they were on their way in. They provided video phones. They provided caption telephones for people who were hard of hearing and had trouble with phones, but didn't sign. They we came up together with a set of auditory enhancements for people who were hard of hearing and therefore couldn't hear um, the classes they were taking, the rehab classes and that kind of thing. We did non-auditory alerts so people would know when there was a fire. Like, we did a whole lot of things, but they all fit into that general idea of detection, planning, and accommodation feedback. And I'll just say one more word about planning, and then I'll subside, which is that um, without planning in advance, you really can't accommodate people with disabilities. You can't do it on the spur of the moment. You can't all of a sudden realize that you need a ramp and have it in place when somebody needs it. You can't all of a sudden realize that you need a sign language interpreter and not have set up the contracting vehicle prior to when you need it, so that when you need it, they can come out on short notice. You can't all of a sudden decide, oh, I need caption telephones. It took us a year and a half to get the caption telephones set up in the Kentucky system, and that's all talking about communications and mobility impairments. But the same thing is true for intellectual disabilities and mental illness. You can't all of a sudden think, oh, maybe I'd better have a system where a person who can't get their GED because of an intellectual disability nonetheless has equal access to parole. You can't like do that on the spur of the moment. You have to plan. That planning should really involve um, a we should all be following the rule that the disability rights movement has taught us, which is nothing about us without us. And that planning should really follow that rule. And it needs to happen really systemically through the entire system, from the first touch point that Leanne talked about to the very last one. Um, so I'd say we accomplished some stuff in the Knights litigation. I wouldn't say that it was all perfect, and I don't have that much visibility into what's been going on since. So I just I don't know. You know, I've lost my better my better access that I had when I was monitoring. But it did suggest that a person who really works at making sure that those pieces are in place, detection, planning, accommodation, feedback, who's empowered to actually change things, can get a lot done in a particular system.
Thank you. Margot, there's a question that came in, and since it kind of has to do with deaf prisoners, I'm just going to throw it out here. How are deaf prisoners supported when communication access is absent?
Uh, I'm not sure I entirely understand that question. I mean, the answer should be that communication access is not absent, and the support that's needed is to change the premise of the question, right? Um, you don't want to provide alternatives to communication access. You want to provide communication access. So if a person in prison, it's a little bit different because prisons provide medical care as well, which means, I mean, outside of prison, if you need a hearing aid, you're not going to get that from your employer. But inside of prison, if you need a hearing aid, you should be able to get that from the prison. And then you have access to communications. If you need a sign language interpreter in order to understand what's being said to you by prison staff, they should be providing a sign language interpreter. If you need, I mean, sometimes it can be very small, but equipping the caseworkers with um, uh, a kind of like a microphone that can go into somebody's ear by Bluetooth can be a phenomenally successful intervention. Um, but you don't want to support the lack of communication. You want to provide communication.
Yeah. There, and I'm just going to throw out this one. I am seeing questions and things come in, so I'm just trying to kind of navigate if we're on completely on a topic, whether or not we can answer them quickly as we go. So before this is to either one of you actually. So everybody's definitely hearing the planning in advance piece, but there are some questions around just basic timing. So if you know that you have to be in criminal court, and you're waiting on arraignment, so you might get arrested on a Sunday, you might have court Monday morning. Is that enough time to find an interpreter or an advocate?
No, not unless you have it set up in advance. So,
Yeah,
so what you need is a contract. What the court needs is a contract with sign language interpreters that says, yep, we'll provide people on 2 hours notice or 6 hours notice or a day's notice. I mean, whatever it is, like what's reasonable depends on the circumstances and the location. But um, honestly, with video interpretation, which isn't great in all circumstances, but will do really fine in some, to answer Ben's point, in the middle of nowhere, maybe you provide video interpretation until you can get a live interpreter, or maybe video interpretation is good enough depending on the situation. Like it's not good enough for an emergency doctor's visit, like it just doesn't work. But it might be good enough actually. I mean, in my county, arraignments are on video. I mean, right? So video interpretation would actually work fine.
great. Thank you. Leanne, so there have been some conversations around some things like specialty courts, and some may even exist in a few jurisdictions. Can you give us some examples of specialty courts and the issues that arise when considering them, especially in the United States? Like, what are the pros and cons as we think about them?
Sure. So, actually, the ARC's National Center on Criminal Justice and Disability has provided some webinars and information on this as we've looked at what could work, in terms of keeping people outside of the system when at all possible. And one of the ones that I learned about early on was actually around fetal alcohol spectrum disorder, or FASD. And that occurs when a woman drinks during pregnancy, and that causes actual brain damage to the fetus. And FASD can be very hard to recognize. It's like autism, it's on a spectrum. Sometimes there's facial features, many times there isn't, for example. But in one area, and this was actually outside of the US, in one area, I believe this was in Canada, they actually started a specialty court just for FASD because of how many people in that area were the rate of alcoholism in that area. So, depending on certain cultures, certain places in the country, you may see specialty courts, even specific to diagnosis sometimes. Um, More recently, last year, I was interviewed by NPR for a story about a court that was focused specifically on youth with autism. And while, we think about the importance of having specific types of interventions like that, I think my question to myself and others, and I have put this in the article, is if we start specializing everything, how do we actually institutionalize that accommodations are needed in every court? And so I think it's kind of a balancing act there because we can only specialize so much. And then we wonder, how do we get that across the board, throughout the country? So there was actually another court we worked with as they were developing a program. Um, it's called IDOTI. It's around developmental disabilities in Rockland County, New York. And that one was looking specifically at how we can keep folks out of the criminal justice system as well. But again, I think the question needs to be how much do we focus on specializing versus making sure universal design is at play in everything that we do. So I think that's a good question for all of us to think about and ensure that in the systems where, because there's not going to be a program like that in every community, and that's the issue. So in the systems where we don't have that, how are we ensuring that those accommodations can be provided?
Great. There was something that actually came up again in the chat. And since I have a background in higher education, and so does Margot, I thought it was kind of interesting asking about, maybe is it time for what, first of all, what are law schools doing in particular to talk about disability for the new cadre of attorneys that kind of graduate on a regular basis? And is this something that maybe we should think about in terms of curriculum?
I mean, you certainly want law schools to address, to offer classes on disability. I mean, no question about that. And you want classes on criminal justice topics to incorporate consideration of disability in a pretty thorough way. I mean, you know, depending on how you count, more than half of the people in prison have a disability. It doesn't always require accommodation. Sometimes it's a medical disability that what it requires is medical treatment as opposed to accommodation. But more than half of the people in prison have a disability, and even more of the folks in jail have a disability because of the way that we've decided as a polity to deal with psychiatric illness. But so I don't think a class on criminal justice topics is complete without talking about disability. So I think it has to be included there. I think that just count me on the side of I'm sort of a deregulator on curricular issues in general. I kind of believe that our students are adults and they should be allowed to take what they want, pretty much. So with those, as long as a disability stuff is offered, and as long as the criminal justice classes touch it where appropriate, like to me, that's the bare minimum. And after that, I think it's really up to our students who are grown-ups to decide what it is that they're going to cover in their law school education.
Yeah, I would agree. I think the offered piece is maybe one of the key components, and it would be interesting to just kind of know what, from a curricular perspective, just in law schools in general, how or when and if those things are being addressed in certain
I
courses.
mean,
But
my
go ahead.
husband teaches disability rights. I cover it in my criminal justice classes, but he teaches the actual class. And I have to say, there was tremendous demand this year for his class. He's got, I don't remember where it landed, but it's like 70 students, which is a
That's fantastic.
crazy number.
Yeah.
So yeah, there is demand if it's offered and well taught. So yeah.
Fantastic. That also means there's hope for additional change. So that's a good thing. So as we wrap up this conversation, I want to make sure that we're giving folks enough time to be able to ask questions and so that we can get to it. I'm going to ask you both to talk a little bit about where do we go from here. So Margot, what does systemic change look like and require from us in order to move the needle forward in our legal system?
Yeah, I mean, I really think that the things that I said were what I was kind of how I constructed the monitorship in Knights and Adams is really the answer. I mean, not that I don't mean that I was so clever that I figured it out. I think that like this is just how you make change in institutions. You you do an environmental scan to understand the situation, and that includes in disability the diagnostic pieces of it, right? You solicit input from people with expertise, including folks who are affected by the issue. You adjust policy, you plan, and you get feedback. And I think that around the government, that kind of cycle needs to be done. I actually think that's the same cycle, just by the way, for racial inclusion too. I don't think it's very different. I think like that's the cycle for changing institutions. And so we should all be thinking about that in our own institutions, and we should be thinking about those that we have any impact on, saying, what are you doing about the change cycle? Like that's what it looks like.
Great, thank you. Leanne, so you have been traveling all over the place, including in the UK and other parts of the world. And you continue to connect with a number of folks who are working in to address intellectual and developmental disabilities in the legal system. What are other countries doing that we might look to for new ideas or opportunities or ways of thinking that we might consider helpful in the United States?
Oh, great question. And thank you for that. And before I hop into that, I did have something to say about the last question.
Oh,
So I'm
I'm
going to
so sorry, Leanne.
No, no, no.
Absolutely.
As Margot was speaking, I was like, I need to say this around that change and how we create that change. So back to when I was talking about the Pathways to Justice model, we use that in our Pathways to Justice trainings to say to officers, attorneys, victim advocates, all of those who are in the training, because it's not just law enforcement only. What do you, now that you know what you know, because we give them this 1 day training, what do you need to do individually? What can you do to provide an accommodation? And we ask them to list that. But then, because they're there as a community of people interested in this topic, we say, now look over this model. What do you need to do systemically in your community to create change? So I think it's important to bring that hope to the table that they have power within their communities to address this. They just have never even been in the same room together many times when we put these trainings on. And so it's giving the template and giving the tools to communities, but also what we're realizing is they need the capacity as well. And there can often be limited capacity, or maybe there's not even funding behind these efforts. And so we need to look at ways to build capacity in finding those solutions at the community level where we know the answers are among people with lived experience that are living this every day. So I wanted to say that. And then secondly, with the international work, that's been like the highlight of my career is being able to really look at other countries because often we have to learn from each other and see kind of dream the different dreams around what could be in this space. And so I like to raise the example of what's called the appropriate adult in the UK. And they are a trained either person, relative, a person who provides supports to children under 18 or what they call vulnerable adults during police detention or questioning. This is actually mandated by their law, and they safeguard rights, welfare, and communication, ensuring that the person understands the process and that they are treated fairly. So there are some examples of what we can look to in other countries like that that we don't have here. And in fact, that was why the National Center on Criminal Justice and Disability was created, because we continued to get calls from family members, from people with disabilities in the system, saying, where do we go for this help? And well, we can't say, call your appropriate adult. It was kind of hard to find those kinds of supports for individuals. And I'm talking everything from someone who gave a false confession to a rape victim. I mean, we were looking at all kinds of cases to ensure that they had those supports. So the appropriate adult is one example. And then also there's something called a justice intermediary that began in the UK, but has actually spread to other countries now. And that's less of an advocate, and that's more of someone who strictly provides support communication. And we do have something similar like that in Vermont called the communication specialist, but they focus more on civil issues and not criminal issues. So, while we may have a little bit here and there throughout the country where we see some glimmers of hope around these issues, we don't yet see it coming to a more systemic solution. And I think by looking outside of our country only and working with other countries and seeing what we can kind of what are the key strategies they use, or how, I know our laws are very different, but we can at least kind of outline and create a roadmap for what could work in our country. And of course, always going back to the research, making sure that everything we're looking at is evidence-based as much as possible as we grow the body of research and as we create some really solid solutions.
Thank you. There is an interesting question that I'll throw out for both of you, and it's about the idea of building specialty courts. There's a question about, is one of the questions to consider, if we build it, will they come? So and and from that perspective, would this further legitimize the concept of mass incarceration? So kind of, I think the question is really about any thoughts on abolition in the work with disabilities in the legal space?
I think it's a really fair thing to worry about. Um, I don't know that drug courts have accomplished. In fact, I'm fairly certain they have not accomplished the ambitions that people had for them, which was to be kind of like a systematic alternative to an incarcerative approach to drug use, because they don't typically understand the kind of repeat course of what rehabilitation looks like. And I think that they sometimes make people feel better about sending folks with drug addictions to prison. So I think that's a very fair thing to worry about. I don't think they always do that, to be clear. I just think they sometimes do that. I'm not aware of evidence that that's happening with the mental health courts that have been going on. Like, I haven't heard that same kind of set of concerns, but I think it's the right thing to worry about, and we need to develop an evidence um, gathering set of um, norms where we don't just do something and say, oh, well, then that's going to work. Like, that's part of the feedback loop, right? We need to try it, look at it, and if it's working poorly or working not as well as it might, or maybe even it's perverse and leading to the exact opposite of what we want, we need to notice and fix it.
And I did want to mention just a quick follow-up on that point that I didn't get to earlier around specialty courts. And for example, we did a webinar specifically on including people with developmental disabilities in mental health courts, how they often end up in mental health courts, and yet it's not the same disability. And so we have to think about where people are ending up and does that really serve the person and how we can better create a system. Again, I would vote for, if we could do it this way, to try and bring that throughout the court systems, educate the attorneys, throughout the country. And I know that's a big ask that we're trying to do that with police. And, this training isn't mandated often. Some state laws may have some requirements around that, but throughout the country, the education isn't necessarily mandated around this. But I think we definitely need to look at, again, the universal approach and think about how we're getting this into all court systems and all police departments and within our victim service professionals throughout the criminal legal system.
Thank you. There's one more question that I just want. We're running very short on time. Technically, I'm pretty sure we're a little over, but I want us to just think about this one last question, and that is, when it comes to kind of a discussion with folks at the community level, all the way from pre-arrest through, post-conviction, is there a particular legal system actor, like attorneys, judges, court administrators, that either one of you feel is maybe an untapped audience or that is a good entryway for disability justice advocates or organizations to start offering more trainings and resources to?
Hmm. That's an interesting question. I think that's really going to vary by the state. I mean, to know what the gap is requires knowing what's covered, and different states have different strengths and weaknesses. So I'm not going to be able to answer that one generically. I don't know the answer. I don't think there is an answer that's a national answer.
Yeah, I think that might be true because that's, for example, in our Pathways to Justice trainings, we look at this by community, and their laws may be different. They may be more passionate about one thing right now because a case just happened. So, and a lot of times, as we know, that's what drives this change. It's what's going on in that state or that community that then brings attention to the topic. So I would say looking at what is going on, and then please reach out to the ARC, our National Center. We look for opportunities to really bring that education into the system as a whole, working with local communities. We have about 550 chapters of the ARC throughout the country, and working with your disability agencies that are really seeking to really kind of change the narrative around this issue within the country. So please reach out if that's something you're interested in. We'd love to work with anyone who wants to do more education in this area.
Thank you, Leanne and Margot, and all of you who joined us today, and for all of your wonderful questions. This is just a quick reminder that there is an evaluation form there's a link in the chat. We would appreciate it if you could take the time to fill that out. And all of our information has been posted in there via LinkedIn and some other ways. So feel free to reach out to us. We would love to be able to continue the conversation. Thank you.